Here in part 2 of the Constitutional Law NCA exam study video that I'm creating for myself, we will take a look at the Charter of Rights framework. So we're going to start with number 1, threshold issues. So that is whether we have the foundations of a charter case. Number 1 threshold issue is whether the case has standing. So number 1, private interest standing from Eldridge. This is the most common type of standing. The government act or legislation directly affects the claimant's rights and freedoms. Second threshold, we have public interest standing. For this, we have the Thorson, the Borowski, and the McNeil cases. So when an organization wants to bring a suit for the benefit of the public, there is a controversial 3-part test. It must A, be a serious issue, and B, that organization is directly affected or has a genuine interest in the case, and C, it must be a reasonable and effective manner of getting the case before the court. That's from the DESW case. It used to be that it had to be the only way to get the case to court. After DESW, it just had to be reasonable and effective. Threshold issue number 3, collateral standing, from the case of Big M Drug Mart. So case has to be in concurrence with civil criminal proceedings. Collateral standing has to be in concurrence with civil and criminal proceedings. For an individual, if you are subject to a statute, meaning you are charged or are able to be charged, then you have an opening to challenge the statute. For the corporation to have collateral standing, must actually be charged under the statute in order to challenge it. Threshold issue number 4 for standing, intervenor standing. So the lawsuit's already going on. The plaintiff is not the full party in the case. There are limitations to their involvement. The court can grant leave to intervene on a case that someone else has initiated, and then you don't have to meet all the standards in public interest standing. In other words, the government or an NGO or an individual. Next up, application of charter. Section 33. The charter applies to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matters relating to the Yukon Territory and Northwest Territories, and to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. So, legislative enactments. This also applies to government actions based on common law. The case is De Genis. 2. Government actors by nature. This includes legislature, executive branches of government, like from the case in Dolphin Delivery. It does not include the judicial branch. It does not apply to court orders and private actions between private parties, again, from Dolphin Delivery. However, court must interpret common law in keeping with the charter values. Government actors by virtue of legislative control. This includes other entities which are governmental in nature or over which government exercises routine and regular control. Cases McKinney, GVTA. In other words, for example, colleges, airports, police, crown agencies, transportation authorities, GVTA case, universities, McKinney case, and hospitals are not government actors, Eldridge case. Bodies exercising statutory authority. so the Charter applies to bodies that are exercising statutory authority, powers of compulsion, acting in public interest, in respect of these specific activities, Priggen case. Can apply to universities as part of their disciplinary proceedings in this way. So university can be considered a body exercising statutory authority when they're disciplining, and may be considered that the Charter would apply to what they're doing. Non-governmental bodies implementing direct government objectives. So the Charter applies to non-government actors implementing government policies or programs in respect of these specific activities. Eldridge case. So this can apply to hospitals if they are providing a service based on government policy or programs. The Charter applies to both acts and omissions of the government, from the V. Rend case, Briend. Section 33 of the Charter goes on to say, Parliament or the legislator of a province may expressly declare in an act of Parliament or of the legislator, as the case may be, that the act or provision thereof shall operate notwithstanding a provision included in Section 2 or 7 to 15 of this Charter. So, the notwithstanding clause allows laws to be insulated from certain challenges on Charter grounds. It's only valid legislation for 5 years, sunset clause. In order for this to be used, it must fit within four categories. Category number 1, a form of political protest. Category 2, an exercise of risk aversion when constitutional uncertainty about how protected rights would be interpreted. Category 3, an exercise in risk aversion as a result of uncertainty about how Section 1 arguments would be interpreted. Category 4, an expression of political disagreement with Supreme Court jurisprudence, in other words, interpretation of the Charter. Is there a violation of a protected right or freedom? The burden is on the claimant, and consideration of sections 2A, 2B, 7, and 15 would go here on an exam. So what is the scope of the right, the protected right? This is generous, liberal, contextual, purposive interpretations in the cases of Hunter and Big M. The Charter, like the Constitution, is a living tree capable of growth. Hunter case. Does the legislation, government action violate rights as defined? So either an unconstitutional purpose or effect may violate rights in the Big M case. You have to look at the purpose and the effects of the legislation. Look at the purpose first. If there is a problem here, you never look to the effects, because effects cannot save an invalid purpose. The Supreme Court of Canada has rejected shifting purpose because parliamentary intent at the time it was enacted is what is important for the purpose of legislation. And finally, the violation must be more than trivial or insubstantial. This is from the Amselem case. Can the violation be justified? The burden is on the government. A contextual approach should be used to consider the value of the right and the limitation and context of the situation, from the Edmonton Journal case, which is looking at the nature of the activity infringed, the nature of the social problem addressed by the law, the vulnerability of the group protected, competing rights and interests, and the ability to measure the harm or conflicting evidence. The contextual approach doesn't reduce the obligation of the state to meet the burden of demonstrating that limitation is reasonable and justified, from the R.J.R. MacDonald case. Section 1, the Canadian Charter of Rights and Freedoms, guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So, is the limit prescribed by law? So, the limit can be imposed by legislation or by common law. Cases, Therins and GVTA. This includes legislation, regulations, common law rules, municipal bylaws, collective agreements, and policies that are legislative rather than administrative. Is the limit too vague or sufficiently precise and accessible? Cases, Toy, GVTA. Vagueness. It is not practical to seek absolute precision in statute. The requirement is that there is an intelligible standard. A limit will be legislative in nature if it sets out general standards or norms that are intended to be binding and is sufficiently accessible and precise. Is the limit demonstrably justified as reasonable in a free and democratic society? The Oakes test from the Oakes case. Is there a pressing and substantial legislative objective? Are the means reasonable and demonstrably justified? There's a proportionality test. A. Measures adopted must be rationally connected to the objective. It needs to advance the purpose of the legislation through a logical link. It cannot be arbitrary, unfair, or irrational. B. Must be minimally impairing on the right or the freedom that is limited. So is there another means that impairs less? It does not need to be the least impairing. It just needs to be reasonable. Case Toy. Vulnerable group. The government must only have reason to believe that their actions were minimally impairing. And C. Proportionality between the deleterious effects and the importance of the objective. Proportionality between the deleterious effects and the importance of the objective. So, weigh the salutary effects against the deleterious effect from De Genius. Are the overall effects of the law on the claimants disproportionate to the government's objective? This is the most common place for the legislation to fail, is in proportionality between the deleterious effects and the importance of the objective. Okay, so deference to Parliament by the court in those Section 1 justifications, case Toy. Vulnerable groups get more deference as they are acting on behalf of a vulnerable group. Singular antagonist case, so less deference when dealing with the liberty of an individual versus the government, compared to a vulnerable group especially. Increased deference, so administrative decisions, case TWU, expression outside court values, in other words commercial speech, case RJR McDonald. Consideration of broad social issues, for example, assisted death, case Carter. Complex social policy, example marriage, Quebec VA. Regulatory schemes, Hatarian Brethren case. Also, when trying to balance limited resources or when trying to weigh competing scientific evidence. Depending on where the Section 1 test fails, the remedy sought will be different. Shaster case. No pressing and substantial objective, strike down the whole legislation. No rational connection, strike down the whole legislation. No minimal impairment / proportionality, more flexibility. You could strike down the whole legislation, you could sever that portion, you could read down, or you could read in. What is the appropriate remedy? Usually is only one type of remedy or the other, but there are some cases that may be able to have a combination remedy of both types. Case Ferguson. We need to have a variety of remedies for charter cases because we are balancing the respect for the charter and the respect for legislation. Shaster. Courts may consider remedial precision, interference with legislative objective, like budgetary impact, how the remaining legislation is affected, ripple effect, and the size of the group to be added. Charter Remedies, Section 24. Anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. 3 possible remedies. 1. Injunction. Force the thing to stop immediately that is causing the violation. 2. Declaration. A judicial statement that is recognizing that your rights are being violated. 3. Monetary remedy. Damages. These apply to unconstitutional government actions. Remedies must be appropriate and just. Case Doucette Boudreau. Main goal of Section 24. Remedies are individual remedies. The focus is to compensate or correct a situation, and that these remedies are highly discretionary. Remedies from the Constitution Act of 1982, Section 52. The Constitution is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Remedies. 1. Strike down. Whole statute is invalidated. 2. Severance. Sever part of the legislation and strike it down. Common remedy. 3. Reading down. Reading out something as if it isn't in the statute. 4. Reading in. So when legislation is under-inclusive, reading something in as if it was there all along. This is a controversial remedy. When the group benefiting is larger than the group excluded, you're just extending a coverage of rights. Reading in is only applicable when legislative objective is clear and adding to it furthers the objective more than striking down, when adding to legislation would not constitute an unacceptable intrusion into legislative domain, and when it does not involve a budgetary decision such as to change the nature of the legislative enterprise. Remedy 5. Constitutional exemption. The law remains in force but is declared inapplicable in the situation. Example, declaring claimant exempt from the government act or action, done in case Ferguson. This is rarely applied. It applies to unconstitutional laws, case Shaster. Same remedies as division of powers. So remedies should be as non-invasive to the legislation as possible, only correct to the extent of the inconsistencies. This is based on where in the Oakes test the justification fails, and that will determine what remedy is appropriate. Once the court decides on remedy, they can order a temporary suspension of the declaration of invalidity. The court can order a temporary suspension of the declaration of invalidity, which delays the effect of the finding of the invalidity so that the government can amend the legislation. If Parliament has not fixed the legislation in the meantime, when the suspension is up, the legislation automatically becomes invalid. Status quo continues until the suspension is up, but there is supposed to be good faith that the legislation is not enforced during the suspension time. This is supposed to be used for economic reasons, not human rights cases. Case Sharawi Security Certificates. Other notes. The Charter and Constitution are the supreme law of the land. Case V. Rend. No one is above the law. Case Ron Corelli. Accordingly, public officials, ministers, must follow the Charter, and their discretionary power must be exercised in a manner consistent with Charter values. Case PHS. Even before the Charter was created in 1982, ministerial actions that were inconsistent rule of law and Canadian values were seen as a gross misuse of power. Government actors must act in good faith and with integrity in an unarbitrary manner. Case Ron Corelli. Next, specific rights. Section 2A. Everyone has the following fundamental freedoms. A. Freedom of conscience and religion. So 1. The scope of the right. Freedom of religion. Freedom of religion. Section 2A of the Charter describes the guarantee of freedom of conscience and religion as entailing the liberty to hold and live in accordance with spiritual or other fundamental beliefs without state interference. Section 2A protects from the case spring M. 1. The freedom to practice religion without interference by the state. Freedom to do religion. 2. The freedom from state compulsion to follow religious practice. Freedom from religion. This is subject only to limitations such as public safety, order, health, or morals, and the rights and freedoms of others. 3. The freedom of religion does not simply protect against state coercion in matters of religion or conscience. It also requires that the state treat religious belief systems or communities in an equal or even-handed manner. In other words, the requirement of state neutrality, case seguente. Section 4 protects the freedom to worship, not the spiritual focal point of worship, case Katunaxa. This is an external limitation to the Section 2A rights. Freedom of conscience. So this was thought to be part of religion, but it is now recognized as an alternative to religious freedom. While freedom of religion protects fundamental religious beliefs, freedom of conscience extends protection to fundamental beliefs that are not part of a religious belief system to non-spiritual morality. Case Maurice. He was an inmate in federal prison and having vegetarian meals for religious reasons. He later stopped practicing his religion, but wanted the vegetarian meals for conscience reasons. The prison refused. Well, the court held the prison had to provide those vegetarian meals for conscience reasons. Section 2A test brought to us by the case Amsalem. 1. A person must show a sincere religious belief with a nexus, connection, to religion. In other words, he sincerely believes in order to connect with the divine or as a function of spiritual faith that a person has to do this activity. This is subjective. It doesn't have to be practiced by everyone, nor does it have to be obligatory. So the claimant can bring expert testimony, as this would be evidence of what their religious beliefs are, and showing that they are following the objective rules of the faith that they subjectively believe in. The respondent cannot bring expert testimony. This would be pitting the merits of religion against itself in a secular court. How to determine if there was a sincere belief? Look at credibility. Do they do things that support that this is their subjective belief? Look if it is consistent with other practices of the person, but not too far, because people can and do change. 2. You must show that the infringement is more than trivial and insubstantial in nature. This is an objective standard from Katunaxa, case Katunaxa. This is traditionally a very broad right, the freedom of religion and conscience, with no internal limitation on the scope. Most cases are decided in Section 1. Some Section 1 considerations. Case Multani. At minimal impairment stage, the Supreme Court of Canada stated that we should adopt a model of reasonable accommodation, where the school must accommodate the religious belief to the point of causing no undue hardship. This does not apply to regulation schemes, case Hatarian Brethren. This is as Multani had offered to compromise and make the Kirpan less dangerous, which the Commission denied, showing that the complete ban was not minimally impairing to Multani's religious rights. Case Hatarian Brethren. On minimal impairment, in order for it to pass this part of the test, the government must show that there are no alternative, less drastic means to achieve the objective. So the Supreme Court of Canada decided that reasonable accommodation model for Multani did not fit here because this is a regulation scheme, in which case the strict Section 1 test should be applied. The court wanted to hear arguments on the nature of the right, in other words, individual versus collective. Subsequent cases have concluded that there is a collective aspect to freedom of religion. Case Katunaxa. It's not the state's duty to protect the object of such beliefs, the spirit. Rather, it's the state's duty to protect everyone's freedom to hold such beliefs and to manifest them in worship and practice. External limitation. Section 2A protects the freedom to worship, not the spiritual focal point of worship. An extension of Section 2A in this manner would put deeply personal beliefs under judicial scrutiny. This would require the state and its courts to assess the content and merits of religious beliefs. Case: Trinity Western University. When dealing with administrative decisions as opposed to judicial decisions and looking at Section 1 justification, there is greater deference to the decision maker. In other words, the court is more inclined to agree with the decision maker. Step 3, in other words, balancing effects, is the most common place for Section 2A cases to be decided. Other considerations. Case: Big M Drug Mart. The court has rejected shifting purpose because this was not the parliamentary intent at the time it was enacted, and that is what is important for the purpose of legislation. So you cannot create a legal fiction about what the purpose is now versus at the enactment, and this kind of argument may be considered disingenuous or colorable. Case: Seguene Preamble. Whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. This is interpreted as a political theory behind the structure of Canadian politics, not created to support faith, not to put one faith above others, or in general at all. The reference to the supremacy of God in the Charter should not be construed so as to suggest one religion is favored over another in Canada. This is not meant to supersede Section 2A. Further, Section 2A is the only religious provision that must be followed. Case: Amselem. Religion is defined broadly, typically involves a particular and comprehensive system of faith and worship, also involves the belief in a divine, superhuman, or controlling power. In essence, freedom of religion is about freely and deeply held personal convictions or beliefs connected to an individual's spiritual faith and integrally linked to one's self-definition and spiritual fulfillment, the practices of which allow individuals to foster a connection with the divine, or with the subject or object of that spiritual faith. So, in order to waive a charter right, the waiver must be 1. Unconditional, 2. Voluntary, 3. Explicit. Section 2B. Everyone has the following fundamental freedoms. B. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Scope of this right, scope of the right to the freedom of thought, belief, opinion, and expression. Freedom of expression is addressed in Case Irwin Toy. It protects the content and the form of the expression. Expression is defined as anything that conveys meaning. This is an extremely broad right with very little limitation. As such, Section 2B cases are usually decided under a Section 1 analysis. Unlike Section 2A and Section 7, corporations do have private interest standing to bring a Section 2B charter argument. The charter will protect all expressions unless it's taken out of protection by form, in other words, violence or threat or violence, Case Irwin Toy, or location. Only public places are protected, Case Montreal City. Core values protected by this right, Case Keegstra. 1. Truth. 2. Political and social participation. 3. Self-fulfillment. These values are why we protect freedom of expression in Canada. Cases will have different outcomes based on how close the expression comes to these values. The further away the expression in question is from the core values, the more easily justified the infringement becomes, but we do still need to justify it. Case RJR McDonald. Also, further from the core usually means the court is more willing to use deference to the legislator. In other words, commercial speech, hate speech, obscenities, noise. Consideration of these values should come under Section 1 justification because the court did not want to put limits on the scope of Section 2B. The Section 2B test from case Irwin-Toy. Scope. Does the expression in question fall within the scope of protection? Form. All content that is expressive / anything that conveys meaning, with the exception of violence and threats of violence. Case Kawaja. Location. Only expression carried out in public places is protected. Case Montreal City. To determine if the space qualifies for protection, look to the historical or actual function of the place. If the historical or actual function of the place is not public, then there is no protection. For example, private offices in a public building are not a public place. Private property is only protected if there is state action on it. Infringement. So whether there is an infringement to this right in either purpose or effect. So purpose would be where the purpose of the government action / legislation is to restrict content by singling out particular meanings not to be conveyed. Effects, where the government action / legislation is neutral as to content, in other words, not expressly limiting expression, but it has the outcome of limiting expression. This is traditionally a very broad right, with no internal limitation on the scope. Most cases are decided in Section 1. Make sure on the exam to state that the further from core values of freedom expression the impugned expression is, so the further from the core values of the freedom of expression that the impugned expression is, the more easily justified the infringement is. However, this will be expanded on in the Section 1 analysis. Case Irwin-Toy. Section 1 considerations. Case RJR McDonald. Consideration of the three core values, truth, political participation, and self-fulfillment, should come under the Section 1 justification, so as not to put limits on the scope of Section 2B. Case Irwin-Toy said commercial speech was easier to infringe upon because it is further from core values. This is true, but do not get carried away with this. Case Irwin-Toy. Minimal impairment. Defined as we're not going to tell Parliament that they have to do the least intrusive thing, but just the least intrusive while still achieving their objective. The level of impairment just has to be reasonable. When considering vulnerable populations, the Supreme Court of Canada said that the Parliament just needs to have reason to believe that their means were minimally impairing, not that they're the absolute least impairing available. Case Keegstra. Hate speech is protected under Section 2B as it conveys meaning. However, criminalization will be a justifiable infringement to prevent harm to the individuals targeted and overall social harms. Hate speech is outside the core values protected by Section 2B, so infringement is more easily justified. Supreme Court of Canada talked about not wanting a rigid Section 1 test for Section 2B. They need a flexible approach based on context. A blanket protection for expression could include things that may undermine the core values of freedom of expression. In other words, hate versus core values. 1. Hate speech is often not true. Hate speech undermines the ability to be involved in politics if you're targeted. 2. And 3. Hate speech interferes with self-fulfillment of targeted people. Case Whatcott. When looking at minimal impairment, focus on the effects of the impugned expression, not the communicator's intent. Some other considerations for freedom of expression. Case Irwin-Toy. When considering vulnerable populations, there will be more deference to Parliament. The further the speech is from one of those, the more easily it will be justified. Promoting the free flow of ideas is essential to political democracy and the functioning of democratic institutions. Participating in social and political ideas is essential precondition for the search for truth. It's a marketplace for ideas. It contributes to the richness of society. Self-fulfillment helps the realization of a person's character and potential as a human being, human dignity, and allows people to express their deeply held beliefs. Case Keegstra. Do not need to show evidence of damage. Hate speech is presumed to be damaging. The defense argued that the criminalization of hate speech had no proof of actually preventing harm. And the Supreme Court of Canada said criminal laws can be preventive in nature. 2 injuries caused by hate propaganda are harm done to the members of the target group. Emotional damage caused by words may be of grave psychological and social consequence, and influence upon society at large. People will believe almost anything if information or ideas are communicated using the right technique and in the proper circumstance. Case Whatcott. Hatred. Extreme manifestations of the emotion described by the word detestation and vilification. Test. The Whatcott test. The question courts must ask is whether a reasonable person, aware of the context and circumstances surrounding the expression, would view it as exposing the protected group to hatred. Section 7. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Scope of this right. As it applies to life, serious threats to life by preventing access to medical care, case PHS. The right to not be deprived of life and protection from the threat of premature death, i.e., the right to assisted suicide, case Carter. Imposing death penalty or extradition to a jurisdiction that has capital punishment. There's a narrow scope when it comes to life in Section 7. Section 7 liberty applies at all stages of the criminal justice proceedings. This involves the freedom from physical restraint, including imprisonment, case BCMBA, case PHS. It's the liberty, the ability to make decisions of fundamental importance to oneself, like having children, like Wilson in case Morgan-Tiller, the choice to end life, case Carter, the ability to make parenting decisions, case Children's Aid Society. Again, narrow scope when it comes to liberty. Security of person has been interpreted as an integrity of physical and psychological self, and it is protected against government actions. Case Morgan-Tiller, case Carter, case Morgan-Tiller, and case Carter. The right to access medical treatment. Case Morgan-Tiller, case PHS. The right to take steps to increase safety of dangerous activities like prostitution. Case Bedford. There's a broad scope to security of person rights under Section 7 of the Charter. Case BCMVA. The principles of fundamental justice is an internal limitation. It allows for infringement on rights. A purposive approach based on the case Big M determines that the PFJ are not the protected rights. The principles of fundamental justice are not the protected rights. They are the qualifier to the right of life, liberty, and security. It serves to set the perimeters of the interest. It must not be interpreted to be too narrow, as this would make it easier to have the rights deprived. Case Children's Aid Society. Violation of that liberty can be in accordance with the principles of fundamental justice if there is procedural fairness. On one hand, liberty does not mean unconstrained freedom. On the other hand, liberty does not mean mere freedom from physical restraint. In a democratic society, the individual must be left room for autonomy to make decisions that are of fundamental importance, And Section 7 and Section 15 have become tied up together because the Section 15 test is very complicated. The Section 7 test comes from Morgenthaler, the case Morgenthaler. Section 7 test. 1. Did a government action violate the right to life, liberty, or security of the person? Did a government action violate the right to life or liberty or security of the person? This is a threshold question. The action must have sufficient causal connection to the violation. Case Bedford. Choice. In other words, to use drugs or to be involved in the prostitution does not negate causation. Case PHS. Case Bedford. 2. Part 2 of the test was the violation inconsistent with the principles of fundamental justice. It will not be consistent with the principles of fundamental justice if there is one or more, case PHS, arbitrariness. 1. Arbitrariness asks whether there is a direct connection between the purpose of the law and the impugned effect on the individual. So you look at A, the objective of the law, and B, a rational connection to limitation on the Section 7 right. 2. Gross disproportionality. So laws are in violation when the effect of the laws are disproportionate to the state's objective. State actions of legitimate responses to a problem that are so extreme that it has a negative effect on the population. Case Malmo-Levine. 3. Overbreadth. Law is so broad in scope that it includes some conduct that bears no relation to its purpose. It just captures too much. It is rare that something is not found. It is rare that if something is not found to be consistent with the principles of fundamental justice, that it can be saved by Section 1, but you must do the analysis anyways. It is not recognized to be a positive right, but the door is open to try and argue. Case Gosselin. Section 1 considerations. Case Carter. If something is not consistent with the principles of fundamental justice, it will rarely be saved by a Section 1 analysis. But they are different analyses asking different questions, so on the exam, you must do both regardless. Section 1 can be an important place for consideration of broader social interest. In other words, where the public good justifies the deprivation, or where societal balance required needs a greater level of deference. Case Bedford. Focus of the Section 7 Principles of Fundamental Justice analysis is on the individual, not the society. So the focus of a Section 7 PFJ on the individual, not the society. Whereas Section 1 analysis focuses on society, not the individual. Some other considerations. Case Malmo-Levine. Principles of fundamental justice is a legal principle about which there is significant societal consensus that it is fundamental to the way in which the legal system ought fairly to operate, and it must be identified with sufficient precision to yield a manageable standard against which to measure deprivations of life, liberty, and security of the person. Case Morgenthaler. Parliament can impose procedures for the operation of a criminal provision/defense, but cannot do so in a way that offends the PFJ. In other words, it cannot create unreasonable barriers to access criminal defense. This creates an exemption framework for abortion, which has procedures so manifestly unfair with so many barriers to its own operation that it offends the PFJ. Case Carter. Trial courts may reconsider settled rulings of higher courts in 2 situations. 1, where a new legal issue is raised. 2, where there is a change in the circumstances or evidence that fundamentally shifts the parameters of the debate. In Carter, for example, this case was brought on different fundamental principles than Rodriguez, the case Rodriguez. A good lawyer is coming up with a new way to frame the issue. In Carter, the political climate about medically assisted dying had changed. Many countries had now started allowing it. There will be more deference in cases where there's a complex regulatory regime. In other words, assisted dying. Or, for example, assisted dying. Case Gosselin. Nothing in Section 7 places a positive obligation on the state to ensure that each person enjoys life, liberty, or security of the person. Section 7 has been interpreted as restricting the state's ability to deprive people of those rights. It is possible to have a new reading of Section 7, the living tree. Therefore, positive rights would be a new reading. It just wasn't supported by the evidence presented in the Gosselin case. Section 15 of the Charter. Section 1. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Section 2, subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Scope of the Section 15 right. The focus is on substantive equality, not formal equality. Substantive equality is based on equal outcomes. Sometimes unequal treatment may be required to create equal outcomes, whereas formal equality is based on equal treatment only. The enumerated grounds is not an exhaustive list. Can also argue for something to be analogous. To be analogous, it must be 1, immutable characteristics beyond the control of the individual, not easily changed, and 2, an aspect of historical discrimination/disadvantage based on this characteristic. Case Cobier. For example, 1, citizenship, case Andrews. 2, sexual orientations, case Egan. 3, marital status, case Myron, case Quebec v.A. 4, aboriginal status plus residency on reserve, case Cobier. Once something is recognized as analogous, it is considered analogous forever, case Cobier, and vice versa. If something is not found to be an analogous ground, unless it can be distinguished and re-argued. So here's what's not recognized as analogous grounds. 1, employment status. 2, occupation in terms of agricultural work. 3, province or municipality of residence. 4, marijuana users, in other words, lifestyle choices. Case Malmo Levine. 5, language. 6, manner of conception. 7, poverty, but this could be challenged as there is historical discrimination. The Section 15 test is brought to us by cases Andrews and Cap. Number 1, Section 15, subsection 1. Is there a distinction created based on enumerated or analogous grounds? The burden is on the claimant. Distinction can be through the purpose or as an adverse effect. Case Eldridge. Section 15, subsection 2. Is it part of an ameliorative program? Case Cap. The burden is on the government. The focus only on the object/purpose of the program, not the effects. A program does not violate the Section 15 if government can demonstrate that. If the government can demonstrate that 1, the program has an ameliorative or remedial purpose, it doesn't have to be the only purpose, or 2, the program targets disadvantaged groups identified by the enumerated/analogous grounds. This is a very strong argument for the Crown. There can be outright discrimination against another group through adverse effects, but an ameliorative program saves it. Case Cunningham. If there is a valid ameliorative program, there is no Section 15 violation. The analysis stops here. Section 15, subsection 1. Does the distinction create an arbitrary or discriminatory disadvantage? The burden is on the claimant. The CAP formulation used to say, does the distinction create a disadvantage that perpetuates prejudice and stereotyping, but now stated as an arbitrary disadvantage, which includes but is not limited to prejudice and stereotyping. Case Quebec v. Case Tapotot. 4 factors from the law are relevant here. You could talk about the effect on human dignity. Some Section 1 considerations. Discrimination is very hard to justify. However, it is possible that a Section 15 violation could be saved by Section 1, so you must still do a Section 1 analysis on your exam. Case Quebec v. Other considerations. Discrimination. A distinction, whether intentional or not, based on grounds related to personal characteristics of the individual or group, which has the effects of imposing burdens, obligations, or disadvantages on such individual or group, not imposed upon others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society. And Section 15 applies to all persons, whether citizens or not. The provision states every individual. Section 15 came into effect 3 years later than the rest of the Charter in order to give time for the government to update the laws to make sure they followed the equality rights. Case Kakawistaha First Nation v. Tapotat in 2015. This is legally important because Abella J. had the majority here and reiterated the test from Case Quebec v. Eldridge. Case Eldridge. There was an attempt to make this about a positive right, and the court turned this around and said the right to equal access to medical services was being withheld rather than there being a right to getting the service as a benefit. Once a state provides a benefit, it has to do it in a non-discriminatory manner, and sometimes this will require them to take positive action. Click like, click subscribe. Check out these other videos on constitutional law and eventually even more Canadian law and NCA exam prep down here in the corner. And best of luck to you on your upcoming exams.